It's another week of the Express Entry and Canadian Immigration Live Q&A. Mark is out of office tonight for a short conference and a webinar where he presents. So I'm hosting this live Q&A with Alicia together again. How are you, Alicia?
I'm doing all right, Igor. I'm holding in there. Yeah, I don't know. It's been a weird little time with I guess with IRCCs and this kind of hiatus on the express entry draws. And so, yeah, I already see that people are saying, is there going to be an express entry draw today? We hope so. I mean, it's been a very long time now, it's over a month since there hasn't been a draw. So that's one thing that we're always looking at. And it does sound like there were issues in terms of the technical side of what was happening on the back end on IRCC processing for express entry applications. And so I thought maybe we would poll our listeners today. If there's anybody who actually got an ITA under that October 26th draw and you're still working on that application, let us know whether you happen to have logged back into your profile and see that they have given you an extra 60 days. So, of course, normally when you get an invitation to apply under an express entry application, you would normally only have 60 days from that ITA to submit your completed EAPR. But it seems like we've heard from some other immigration lawyers that it seems like some people they didn't initially have a whole bunch of time, but when they've logged back in recently, they've seen that IRCC has added an additional 60 days and they're trying to figure out if they trust it. Do they wait, and use that extra time because of the glitches in the system, or do they just kind of hustle and try to go with the initial 60-day period? So maybe we'll do a poll. If anybody has received an ITA under that October 26th draw, just drop us a note. Let us know if you have seen an extra 60 days appear in your EAPR profile. So that was one thing we wanted to talk about today. And of course, as always, we are here. We're the Canadian Immigration Institute, and we have a law firm. So we are here for Holthe Immigration Law, and I've been at this for about 20 years. Igor is our articling student. He, of course, was a lawyer before, and he's now getting retooled for Canadian immigration law. And we are here to help answer people's questions. And we're trying to do this to make sure that we are answering as many questions that are relevant to a broad population as possible. We're not going to be giving you immigration legal advice because we just simply can't do that professionally on a little Q&A. So if you do have questions and you want follow-up information, if you're asking things that are very particular to your life circumstances, please flip on over to our Holthe Immigration Law website, and maybe Igor, you can pull that up and show the listeners where we are, but you would go to Holthe Immigration Law, and if you need specific immigration legal advice, then please book a consult, and we will be able to help you there. So yeah, you just go to the Holthe Immigration Law website, click on the Speak to a Lawyer, the big red button there, and we can definitely talk to you one-on-one. But for today, for this live Q&A, we're here to try to answer the questions that you may have and talk about all things Canadian immigration related. So maybe Igor, we can get started with a few shout outs for people.
Yeah, for sure. So we have hello from Almonds, and Ravenna, she asked whether there will be an express entry draw today, and we've addressed this briefly. It's been over a month since the last draw. And then we have a message from Urshad from LinkedIn, which is really cool that people tune in from LinkedIn. And we have our super nice guest, Hamed. Hamed was our client. And thank you, Hamed, for tuning in. It was a pleasure to work with you, and I'm really glad to see you here again. And then, Alicia, we do have a super chat from Mahima. And so let's dive straight into this. So she's asking, if she declines an ITA, does it mean she has to update her profile and choose yes for the option whether she applied previously for express entry, or should it still be no?
Mm-hmm. And this is a question we often get. It's one of the questions that's covered in the do-it-yourself course for express entry. So yeah, if you decline an invitation to apply, technically, yes. Technically, it's easiest, it's most comprehensive to go back into your profile, and when it asks you, have you applied before, just say yes, and then put that prior express entry profile number that you had. Like if you only had an ITA and you didn't actually submit the EAPR, arguably you didn't submit the application, but because it's going to be in the system anyway, you might as well acknowledge it, and you might as well point immigration to what your old profile was and just acknowledge it. Just say yes, put the old profile number, and basically you're saying yes to those two questions.
Okay, perfect. Let's see, what other questions do we have? And I'll go through the questions chronologically, so if you post something, it may take a little while before we get to your question, but let's take a look at this one. So, hi Igor and Alicia, I see COPR on tracker for CEC application. Will it be 5 months on Friday? Still no communication. Do you advise to go to USA for flag polling, or what do you advise?
OC, I almost never, ever, ever recommend that you flag poll. Almost never. It would have to be something extremely specific, and you would have to have a really desperate reason to have to go to flagpole. I definitely hear you, and I sympathize on, 5 months on waiting for that COPR with the tracker is super, super long. That's not reasonable, and I would recommend, instead of going to the border, do not flagpole. I would not recommend that. But instead of doing that, go on to the IRCC application. So maybe, Igor, you can pull it up. There's the old web form, which takes a very long time for IRCC to respond to, and there's kind of the new web form. We haven't we've talked about it a few times, ask about or update your application. We've shown this to people before, but these ones, I don't know about you, Igor, I have found a much faster response rate on these. So we submitted one of these to update an application last week, and within 3 days, we got a response back from IRCC, and they were responding to actually what we had submitted. So these ones seem to be good. So if you go on to here, you're going to probably send them an inquiry through one of these boxes and say, here's the proof that I submitted my application. It was approved. It was confirmed. Here's the date that I received this. Here's my COPR tracker saying that the CEC application is completed. I still have no communication. I'm worried about the processing of this file. Please, can you get back to me? And I would do it through this.
Okay, perfect. Then, Alicia, we have the next question from Iftak, and he says that if he gets an OINP nomination, does it guarantee that the COPR will be issued to him as well? Basically, does this mean that his application is approved?
No. So keep in mind that any provincial nominee application is a separate application. So you have federal requirements. So there's the things that IRCC requires in terms of express entry. And I'm assuming that you're looking at an express entry linked provincial nomination application. Some of them are and some of them are not. But on the express entry linked PNPs, you have to make sure that you're also meeting all the requirements for either federal skilled worker or federal skilled trades or CEC. And then you also have to meet all the provincial criteria for OINP, for example. If you use the same kind of documents that you use for work experience, sometimes there are slight variations in what a provincial nomination category requires for your work experience letters and support and pay stubs and things like that versus what the federal government requirements are for work experience letters. So when we work with clients, we try to be very comprehensive and make sure that the letters are doing double duty. But sometimes there's additional things that you need to be aware of for those PNP applications. So be very careful, look at all the program guidelines for the OINP, and also go directly to the legislation. So each province has legislation as well, or most of them do, and you'll want to double check that to look at the fine details. And then also when you're going on, if the province gives you that nomination and you get the 600 points, then you have to wait for a federal invitation to apply. There has been this hiatus, right? So a lot of people are waiting. They have their nominations and they don't have an ITA yet because there just simply hasn't been any draws since October 26th. Once you get that ITA from the federal government, then it's a matter of making sure you're meeting all the completeness check requirements for the federal side.
Yeah. Okay. We'll move on to the next question, and this one is interesting. So Rishabh, due to a glitch in Google Maps, somehow got to Canada through a rainbow peace arc. And his question is, should he mention this in a travel history or letter of explanation?
Yeah, and so Rishab, this is, kind of bordering on a question that's pretty specific and that, you're looking for advice. So I can't give you advice, but I can generally say, like, you can for sure reach out and book a consult. But if you did cross the border and you didn't mean to, and it was something that you acknowledged and the officers knew that that had happened, you do want to acknowledge it. You want to say any time that you have had something irregular happen at the border, because on your Canadian immigration background declaration questions, it's saying, were you ever refused entry or turned around or denied or refused a visa? And so if you were in a situation where you didn't have your passport, you happened to go into the US, but you didn't have documents to enter the US, I've seen situations where people hadn't used us as lawyers, but they had filed their own application. In the past, they had done something kind of similar. They had tried to flagpole in order to get their work permits. They were kind of in no man's land between Canada and the US. The US wouldn't let them in and turned them around to Canada. And then on the Canadian side, they actually got the work permits issued. And then they filed their application for PGWP, and then they went on to do express entry. And immigration came back and said, what about this refusal to the US? And they were like, what refusal? What happened? And then they remembered that they were, tried to do this flagpole, weren't allowed into the US, and then sent back to Canada. And they thought because they got their Canadian work permits, everything was fine. But in fact, the US had records showing that they were denied entry to the US. So it's always very important to be very thorough and to really go back through your records, make sure that you've got the right dates, comb through your memory, think about prior visa refusals, or even times where you were not allowed into the US or directed back. So be very careful about that.
Okay. And then this one is from our past client, Anastasia. Anastasia, nice to see you. She's asking if she, as a temporary resident, can contribute to RRSP or first FHSA, first time
Home buyer
home
savings plan.
savings.
Yeah.
Yeah, that's
Yeah.
the account that I had to deal with recently. Um, it's a different story. It's a little painful trying to set it up and take the money out of this account. But um, Alicia, do you know the answer to this question? I know
And
for RRSP, I'm not exactly sure for FHSA.
yeah, I don't know about the FHSA for temporary residence, Anastasia. So maybe check with an accountant or a tax lawyer, because this is getting into the realm of non-immigration and into tax law. And I always say go directly to a tax lawyer or a tax accountant who can give you the up-to-date information on that. But you're right to double check that to make sure that you're getting correct information on that, because you don't want to be in a situation where you're offside on taxes for sure.
And Anastasia, I can send you an email with a link to the page where you can double check this information. We have your email, so we'll send it to you. We'll move on to the next question, and let me just find it. Okay, Kathan was asking if the employer changes logo. The logo would be compared to the pay stubs, right? And would this make this case more complicated for the officer? Does he need to explain it?
And Kathan, again, like this is something where it's helpful to get more information from you in terms of what the corporate structure was, what kind of employer were you working for? Was it like a small kind of individual mom and pop shop, like a local business? Was this a multinational company that was going through rebranding? Um, Usually what happens when we work with people when we're doing an express entry application, I want to take a look at what those letters were. Sometimes people have older letters from their employers and then an updated employment letter or employment verification documents. Sometimes they have pay stubs under an old letterhead and then a new letterhead. And if there is something that I look at and I'm asking questions about, I normally recommend that the clients just write that into a letter of explanation or have their employer just mention in their letter of employment we went through a rebranding, we changed our logo, we changed our website, or sometimes you can actually go onto the internet and find some sort of public announcement from the company about when they changed their logo. So that's just something, some ideas, but for sure reach out to us if you've got more questions. But it is good to kind of think critically and say, is this something that would cause me concern if I were an immigration officer looking at this application, or is it something that people would ask questions about? And if it is, you'll want to just address it head on and try to find some supporting documentation to show when that logo change happened.
Yeah. The next question is from Omkar, and I wish I had this bell sound, which would signify that Omkar, you would need to book a consultation so that we can look at your work experience and tell you exactly whether you can claim points or you can't. There are so many moving parts when it comes to answering this question. So let me share my screen. I'll show you where you can book the consult. So you go to our website, holthelaw.com, and then you click Speak to a Lawyer, and then you can choose whoever you want to speak to and get your consultation. Alternatively, you can go to our Expert Entry course, which will guide you through all of these questions that you have about Expert Entry and work experience. And Alicia, our work experience section in this course is just amazing. We have template work reference letters, we have knock selection tool, hours of work tools, so many different guides and tips and tools that will help you prepare the work history section for your Expert Entry application. So Amkar, check this out or reach out for help if you want to talk about your work experience. Alicia, what do you think about this question? Shagufta is asking if there's any delay for FSW applicants from India in light of this diplomatic conflict that we had.
It's tricky to say. I mean, you can always go to the IRCC processing times and take a look and see what it's currently listing. And maybe, Igor, you can flip over. And we do this almost every week. We almost always go to the IRCC processing times and show people how to check. Hopefully, I mean, the nice thing about everything going digital and having an integrated system now is that officers are able to send files wherever has capacity around the world in terms of their network. But, it's generally slowing things down to be missing a whole bunch of IRCC officers because, of course, Delhi and the processing centers in India had a fairly large number of immigration officers. And so this is for sure not a good thing in terms of processing overall. And the processing times are currently listed at 5 months, which is fairly lengthy.
Yeah. All right, so we have a message from Marinder and a message from Anurag. Anurag is asking that, is it fair to say that people who don't have any ties or connection to Canada, such as like family, job, education, they don't have any chance of getting a permanent residence?
So, Anurag, it's for sure harder, right? All those things kind of give people a leg up in terms of being able to maybe get some more points in terms of relatives or have kind of for sure a job offer is a strong way of being able to kind of work your way into arranged employment points, which gives you those 50 points. There are potential ways sometimes to get permanent residence if you don't have kind of a education in Canada or a relative in Canada or a job offer in Canada. But right now, a lot of those involve being a French speaker. So if you have very strong English skills and you have very strong French skills, that might be enough to be able to get you in under a targeted draw. So that is one way that even without a Canadian education or family members or a job offer, it could be possible. If you've got strong education and strong language, especially English and French, then you could potentially have a strong CRS score and get a targeted draw under the French speaker category.
Yeah. And we also do have clients who get drawn under different categories. Agricultural stream. We have one of the clients, and we've submitted an application, just waiting for the result. Hopefully, it will come back soon. But that client did not have any connection to Canada, though that client knew French language. So there are still some ways how you can get your desired ITA, and developing an immigration strategy can take some time. And if you need help, again, reach out for a consult for us. Okay, Angela is asking, does the province have something to do with the temporary student visa in terms of, does the province where you're destined determine the likelihood of your visa getting approved or not? So she got refused a student visa application, and now she thinks to apply for a DLI in Saskatchewan.
Yeah, and Angela, like I would recommend that you reach out and speak to us directly in a consult because, and maybe Igor, you can even pull up, I have an old article on the blog about top 10 reasons that study permits get refused, but often a study permit is getting refused because there are other factors that an officer is suspicious about. And so you want to address those root factors, and it's federal. That does bring up a good point, and I'll get to that in a second about the changes that are happening to what's going to happen with study permit processing as of December 1st. But take a look at this article that I wrote, Top 10 Reasons for a Study Permit Visa Refusal in Canada. And some of them are, you just have been out of school for a long time, or you didn't have good marks on your initial program of studies, or English or French language levels are low, or you don't have enough money to be able to show that you can actually support your studies in Canada, or there's no real logical connection between what you were studying, what your career path has been, and the program that you want to take in Canada. And then temporary intents. You still have to show what your ties are to your home country relative to your ties to Canada. So if everybody, or you've got a number of siblings in Canada and family members in Canada, that draw to Canada is pretty strong. And so be really careful about filing another study permit application until you've addressed those root causes or concerns that the officer is probably going to have. Now, what's also going to happen, because there have been integrity problems in the study permit processing, we've had issues where there was fraud. And so the government is trying to crack down on study permits, and they're also trying to crack down on designated learning institutions. And so keep in mind that if you are a student and you're looking for a study permit, you must be applying to a designated learning institution in Canada. And that's not only universities, it's colleges, it's other public institutions that are on that list. But what has happened is immigration is now saying there needs to be a second level of verification, especially with respect to letters of acceptance. So what has to happen as of December 1st, which is Friday, so in a couple days now, there's going to be a new study permit application form, a new IMM 1294. So that new IMM 1294 is going to have more details about that new LOA, kind of how the letter of acceptance process will work. But then it will involve a little bit more of the provinces and the designated learning institutions within the provinces, because what will happen is each province is going to be responsible on making sure that their designated learning institutions are kind of up to snuff, that they are doing what they need to be doing to be a reputable institution and confirming letters of acceptance within a fairly quick processing time. So take a look. This is the IMM 1294 that Igor pulled up for us. Again, IRCC uses all these PDF forms, so that's why it gave you the error message. You have to download it, you have to save it, then you have to open it, and then you've got to go to the bottom, just like Igor showed us. Maybe go to the bottom again, Igor, and just kind of show the viewers what we're talking about here. But if you look at the very bottom, it's going to have a date. And right now it's the IMM 1294 and it's the 09-2023. It's the September version. They're going to need to have the December version as of December 1st. So be careful with these study permit applications. Be careful with the new rules that are getting rolled out for letters of acceptance. And it's possible that if the provinces are not kind of cracking down on their provincial learning institutions and they are not putting in kind of safeguards, if they're not having a way to have students get affordable housing or student housing, if they're not acting ethically in terms of how they take deposits and things like that, it's possible that the federal government could shut down some of these DLIs or take them off the list. So do be careful that you're looking at reputable schools. So in that respect, you have to look at what's going on in the province, but I would recommend for you to look at the bigger factors, those top 10 reasons that study permits are getting refused, and address those before you do another application.
Yeah, and then if you apply one time to university in Ontario, and then you apply next time to university in Saskatchewan. And if your application gets refused and you apply for a university in BC, guess what? What question will the officer have? Like, do
Hmm.
you actually have a plan? Like, do you actually need this education for your long-term goals? And is there a progression? Why are you applying for different schools every time?
Yeah.
All right, so let's move on to this question from MX. And he's asking, if someone has an overstay in another country, will this have a negative impact on police clearance certificates or the security check for express entry? I can
Hmm.
attest from my my
Go for it, Igor.
experience.
Yeah.
I had an overstay in US. It was a fairly long overstay, and it did not have an impact. But the officer was concerned for sure, and we're still debating whether they they pinged the U.S. immigration authorities and shared the information about me being in overstay, or it just happened by coincidence. There's still no certainty about that, but we do believe that it might be a coincidence. But at the same time, it's really sketchy in terms of the timing. Is just is it cannot be coincidence at the same time, you know. So yeah, overstay definitely does not bar you from permanent residence unless you disclose, unless you decide to hide it. If you hide it, then you don't have a shot because sooner or later they will learn about it, and it's better if they learn it about your overstay from you than if they find it on their own and um, they just bar you for 5 years for misrepresentation. So be very truthful about your overstay. Explain all aspects and details. And if you need assistance, again, little bell sound, you should reach out for a consult to us, and we can talk in detail about your specific situation. Because right now, it's hard to tell you exactly how it will impact your police clearance certificates. In some countries, it may be illegal and subject to criminal penalties, right? And so they will not let you get a police clearance certificate. And some countries don't issue police clearance certificates for bizarre reasons. Like in United Arab Emirates, you wouldn't get a police certificate if you have a loan. That is not a case in any other country. So whether it will have a negative impact depends on where you overstayed and for how long you overstayed and what was your situation. So that requires a little more information from you before we can answer your question.
Yeah, and absolutely, Igor, you're completely right. Like you always have to disclose if you are refused a visa. So it's very clear. There's lots of federal court case law that says if somebody fails to disclose a visa refusal in another country and the officer says, all right, we're going to find you in violation of misrepresentation, that you've misrepresented the case, then they will give you a 5-year bar. You cannot apply for permanent residence. You can't apply for temporary residence. You're inadmissible to Canada. And that's going to be a mark against you for any future application as well. So be super, super careful that you disclose that you did have an overstay. And exactly as Igor said, some countries that might affect the police clearance, depending on whether it's an offense or if it's a reason why they wouldn't issue the police clearance in the first place. And then we can get into issues of criminal inadmissibility and whether it's equivalent. So if it's an offense in some countries to have an overstay, would that be equivalent to an offense in Canada? And we could take a look at how that works. But always you have to disclose. And then it's up to, working with a lawyer who's talked about or who understands criminal inadmissibility and equivalency to decide whether that's something that could make you inadmissible for criminality. Most of the time, not usually. Most of the time, it's just an overstay, and you just have to be careful not to misrepresent.
Yeah, Alicia, we have another super chat from VK, so we're gonna skip a few questions in the list just to get to this one. So VK is asking, so he's on a LMIA based work permit, I guess. And then he submitted an express entry profile and got an ITA. and then once he entered Canada on an LMIA-based work permit, can he submit EAPR from inside Canada? VK, please correct me if I misunderstood your question, but it looks like this is what you've been asking. Do you
Yeah,
interpret it differently, Alicia?
I'm a little bit confused, VK, by your question. Okay. Can a work permit only LMIA submit profile? So usually you don't get the work permit until you actually enter Canada. So normally what happens is the employer applies for the labor market impact assessment. If the employer is approved and you're added as a named worker, then you make the application for the work permit. Sometimes, depending on your nationality, you have to make that application from outside Canada as an online application for the work permit. If they then ask you for your passport, if your visa required, and then give you an approval letter, then you would travel to Canada and get that work permit actually issued at the airport or the port of entry. You can submit a profile into the express entry pool. But if you're trying to claim arranged employment points, and I think maybe this is where you're going, if you're trying to claim arranged employment points, if you don't have the physical work permit yet, then technically you should not be claiming those arranged employment points until you have the physical work permit. Because if you look at those drop-down questions on arranged employment, it says, is the employer listed on your work permit the same employer that got the LMIA? So if you don't yet have the physical work permit, then you need that before you can claim those 50 arranged employment points. So be careful with that when in terms of how you set up your profile and in terms of when you're claiming arranged employment points.
Okay. Yeah, and we also have another question, and sorry, I'm just a little bit lost in my screens. This one is from Yuander, and Alicia, Yuander asks you that C20 is not eligible for Alberta Opportunity Stream. Do you still think it's worth to apply through AOS within a C20 work permit?
Yeah, so you're right. We did get an answer back, and so this is one thing Mark had copied everybody. So AOS had actually responded. So the Alberta Provincial Nominee Program said, okay, for Alberta Opportunity Stream, we're sorry, but too bad. For when we say a work permit transfer from a foreign company to a Canadian company, under that definition, it's fairly vague on the website, but they got back to us in an email and they said it does not include C20. It does not include a reciprocal work permit. So unfortunately, that is their answer, and it's highly unlikely they would turn back on that answer. Their interpretation is we're just not going to consider AOS applicants who have C20 work permits. So unfortunately, unless you can go back to your company and say, do you qualify for an intercompany transfer? And it would be tricky because you would have to be working for 1 year in the foreign company and then apply to come under an ICT to come back to Canada. So it's probably not going to work for you because Alberta has confirmed that C20 work permits don't count under their categories for what they will accept for AOS. So that door is probably closed and you'll be needing to look for express entry or other programs to see if you might qualify for something else.
Okay. We'll jump back to the questions that we've skipped. This one is from Parzival. And so Parzival got a nomination from Ontario, and his PR application is processing, but Parzival got a job offer from Vancouver. And so does he need to inform Ontario or RHCC? And what should be the strategy?
All right. And so Parzival, same thing. Ding, 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 ding. You've got to definitely reach out and talk to us because this is for sure immigration advice. We need a whole bunch more information about what your life circumstances are, how long ago you submitted that application. Keep in mind, you do have a positive obligation to inform both the OINP and IRCC of material changes in your circumstance. And if you've got a nomination from Ontario and you submitted an application to Ontario with an intent to reside in Ontario, it's going to be very disingenuous for you to say, oh, now I'm moving to Vancouver, and trying to say that you have a valid intent to stay in Ontario. So the risk, of course, is that IRCC and OINP. So OINP can cancel your nomination. And then as soon as you lose those 600 points, then IRCC says you no longer meet the program criteria, and they will cancel your express entry application as well. So be very, very careful here that if you have an intent to reside in Ontario, you have to maintain that intent to reside in Ontario.
Yeah. Next question is from Sam. Sam is asking, what are the advantages and disadvantages of applying for postgrad work permit after graduation? Sam's husband lives in the US, and then the question cuts out. Okay, let's see. Maybe there is an extension of this question somewhere else. Yeah, maybe this one continues the same question. My H1B Open Work Permit was approved. Planning to move to Canada next year, late second half. When I will go to the border, will CBSA officer issue 3-year valid open work permit from the date of entry? So this one is a little bit different in substance, but Alicia, let's talk about postgrad work permits. Are there any disadvantages? I know of one, but it's not really a disadvantage.
So, and Sam, I'm a little bit confused about why you're talking about PGWPs and the H1B. So I'm not sure, maybe one of you is studying and the other one has the H1B Canada visa. I'm not sure what's happening with your situation here, but keep in mind that if you want to get a study permit in Canada, you need to make sure the school, the Canadian institution, is a designated learning institution, a DLI. And maybe, Igor, you can even pull that up so people can see where you can check if your school is a designated learning institution. But it is super, super important that the school is a designated learning institution, especially because there are now these changes forthcoming about maybe schools are going to get unenrolled. So go and take a look. You can go down to the bottom and it's going to have, you can filter by province to try to figure out, is it a designated learning institution? And then on the right, the other thing that's super important is it says on the very far right-hand column, offers postgrad work permit eligible programs, and some schools do and some schools don't. And you need to be careful to double check with your school to see whether the program even within that school is for sure postgrad work permit eligible. Some of them are not at all. And international tuition fees are extremely expensive. If you are spending, thousands and thousands of dollars on your education in Canada, and you don't realize that the program that you signed up for is not PGWP eligible, it means that there's no work permit at the end of the day, right? And one of the things, there was a report recently that sometimes students are getting their study permits, but they're not actually enrolling in school, which is a breach of your study permit conditions. But some students are using that study permit as an ability to work, which is not at all what the government intended, because they have these temporary public policies right now, which, by the way, are ending at the end of December. So be very, very careful. No full-time work after the end of December, even with temporary public policies. That all ends at the end of December. So the advantage of a postgrad work permit approved program at a DLI is that if you do an 8-month program, you can get an 8-month PGWP. It's an open work permit. If you do a 1-year program, you can get a 1-year PGWP if it's eligible. If you do a 2-year program, instead of getting a 2-year postgrad open work permit, you get 3 years. So this is where the best bang for your buck is getting a 2-year postgrad work permit eligible program, which will result in a 3-year eligibility to work on an open work permit, which you can get Canadian experience on, which is going to maximize your chances for express entry. So that's why that's usually an advantage. And Igor, if you want to go through a disadvantage, go
Yeah,
for it.
disadvantage is also connected to this last point that you've raised, is that once you get a postgrad work permit, it's done. You cannot get a second postgrad work permit. So if you studied once, you got 1-year postgrad work permit, and then you decided, oh, I love Canada, I want to stay for more, and the education is great, and then the opportunities with the postgrad work permit are great. if you go and study for 2 years more, you will not get a second postgrad work permit. So it's not a disadvantage. It's probably a limitation of the postgrad work permit that you have to keep in mind at all times. And so you have to plan strategically how you want to use this postgrad work permit to get this valuable work experience and then apply it in your home country. Or if you want to stay for longer, then how do you use it to extend the time like to a maximum?
Yeah, and there are some technical things about program stacking. So sometimes if you do one program that's PGWP eligible, and then you're able to do another full program that's PGWP eligible, and you're able to do those two one-year programs back to back without a gap in your studies, then you can do what's called program stacking and count two separate one-year programs as a two-year program and then apply for your postgrad work permit. But Igor's absolutely right. If you make the mistake and apply after that first 1 year for your postgrad work permit, you're done. And this has become really confusing because IRCC has done all these 18-month extensions, but they're not extensions. And Mark and I always debate about this because I don't want to ever call them extensions because Igor is totally right. One and done. Postgrads are one and done. You only get one. And the only reason that IRCC has been doing these extra open work permits is through a public policy. But it technically doesn't extend the postgrad work permit. It's just you had to have held a valid postgrad work permit in order to get the public policy 18 months. So be careful with that.
And with all the wrath unleashed on international students, I don't see other extension coming.
I don't think so. So yeah, make sure that you're stopping your work by the end of December. Make sure that you're graduating and fulfilling your study permit conditions so that you can properly apply for your postgrad work permit without having unauthorized work or study.
Next question is from Nanuelego. And Ugo, I'm sorry if I mispronounced your first name. So his question is as follows. What happens if a candidate has gotten a nomination and a work permit support letter from the employer but did not receive an ITA? At the same time, the same employer goes ahead and informs the employee that they are terminating his employment. What happens to 600 points this candidate received since he has not, before he got an ITA? Let's put it this way. His current work permit expires in February 2024.
Mm-hmm. And so, yeah, Ugo, again, I'd encourage you to book a consult because there's a lot of moving parts here in terms of what your ethical responsibilities are and what you can rely on for points. But of course, if you have an employer support letter, I'm not sure why you're saying 600 points. So normally, oh, because of the nomination certificate from the PNP. Okay, so you got a work permit support, not for the 50 arranged employment points, but a program that required an employer to be employing you in that province. A lot of the provinces have employer requirements. So you have to be employed by an employer within that province who's going to support your application in order for you to meet the program criteria for the PNP. And if that falls apart, then some provinces are pretty brutal. Alberta's really brutal. They just don't care. They're going to cancel your nomination unless you can prove to them that you got a new job. So that is sometimes what happens. If you can hustle and try to find another job as soon as possible to get another employer to take over that support letter and then update that with the PNP and say, hey, here's this new employer that's supporting my application. Even then, usually the province will then need to issue a new nomination letter, especially if there are employment restrictions on your nomination. So you'll have to work with them and kind of negotiate with them to get them to transfer that to a new employer. If you don't have a new employer, it's even worse because the risk is they're going to cancel your nomination altogether. But you need to be honest with IRCC and also update your profile so that it's valid. Like if you don't have an ITA yet, you can't have a profile that has a misrepresentation in it. And so you'll need to go in and change your profile to say that you no longer have that valid offer of support from the employer. But there's a lot of moving parts here. And so really try to find a new employer who could take over that nomination and be the new employer of record for the PNP application, if at all possible. And then you're going to have to negotiate with the PNP, usually to get them to transfer that nomination letter.
Yeah. And Alicia, as we're trying to answer some questions, we may skip through some questions. So we have a complaint from Savant. He says, both my questions not answered. Please help me. So let's try to find Savant's question. He asked the following. So he has applied for MPNP, did not work full-time out of province, so does it necessary to cut 100 points in application for MPNP? Bell sound, Alicia, or no bell sound?
Yeah, Savant, this is so part of the reason that Igor skips some questions is if they're ones that require you to book a consult so we can understand exactly what's going on. We can't give legal advice if we have one line and we don't know what's going on in your situation. It wouldn't be professional for us to do so. We really need more information from you about, when did you apply? When were you working full-time? When were you working part-time? Why were you out of province? Do you still have a valid temporary intent to be able to stay within the province of Manitoba? So these are all things that we'd need more information about.
Yeah. We'll go to this question from Skirmishes, and this person is asking, do you need to prove strong home times when applying for permanent residence after you got an ITA?
Yeah. And
No.
so no, skirmishes. So there are different requirements for temporary applications and different requirements for permanent applications. Where the rubber hits the road and there could be a problem is if you're applying for an updated work permit. So let's say you're in Canada and you're trying to apply to extend your work permit and you have to do like a bridging open work permit application. That's where you would have to prove temporary intent and your ties to your home country, and the fact that you still have a valid temporary intent, even if you have that dual intent under Section 22 of the Act. So but in general, if you're outside Canada and you're doing an application under federal skilled worker and you don't have any temporary residence application, you don't have a study permit or a work permit or a visitor visa in process, then as long as you're just doing a permanent resident application, you don't have to prove ties to your home country. Immigration knows that you're applying to come to Canada for permanent residence. So it's only in situations where you have also a temporary resident application like a visa, TRV, or a work permit or a study permit that you have to worry about that.
Yeah. Next question got split into two messages, so I'll start with the second one first to give some context. Working on the ship as a mariner from Portugal, and then 12 years of work experience, rotation 6 months on the ship and then on shore. Due to international labor regulations, can this person claim full-time work experience? And I think this directly relates to those transportation draws.
Mm-hmm. Yeah.
Yeah.
And Kevin, we've talked about this on a few other live Q&As as well. Mark and I have gone through this question a few times, and it really depends on whether you're getting paid, right? Are you getting paid for those 6 months off or a part of those 6 months off? Is that accumulated vacation? As long as you're being honest in the way that you are declaring your work experience and claiming points for your work experience, and as long as you meet the minimum eligibility criteria for either CEC or FSW, you might be able to make an argument in your LOA, this is how it works, right? Or LOE. But if you are misrepresenting in your work experience, if you're claiming a period where you're not getting paid, that's a problem. If you're not meeting the minimum eligibility criteria for FSW, it has to be 1 year continuous work within the last 10 years in a primary knock. So just be careful that you're meeting all the minimum eligibility, that you're properly declaring your work experience in your work experience fields in your express entry profile, and then follow it up with your letter of explanation if you're going to take a run at it. If you're honest, then there's no way they can say you've misrepresented.
Yeah. So next question would be from MX, and we've answered the question from MX before. He's saying, I have a tourist visa, refusal to Canada. Will I have to declare it in express entry? If yes, at what stage?
Mm-hmm. Yes, absolutely. So immigration is going to ask you a few questions. One is, have you ever been refused a visa to Canada or any other country? And a lot of people miss that. So it's Canada or any other country. You've got to declare all of them. And of course, they're going to have records on that. So you want to clearly say what happened, why. Most people will have a refusal letter, and I often recommend that in your letters of explanation, you add that refusal letter and just discuss what happened. In your Express Entry profile, they don't give you space to say that, right? They just give you your fields. It's only if you get an invitation to apply that then you get the EAPR fields, the full kind of expanded fields. Some of them are pre-populated from your profile and they're kind of grayed out. You can go back and change them, but most of the time it's pre-populated. And then there are additional questions. One of them is the additional background questions. And that's where it's going to ask you that question. Have you ever been refused a visa to Canada or any other country? And that's where you're going to provide your explanation. And then at the end, once everything is green and you get to progress to the next section, you can always go back, but once you get to progress to your online document checklist in your EAPR, it's going to give you a bunch of upload spots. Sometimes it's tricky to get all the PDF file sizes to be able to fit within those upload fields, but you'll normally have a client information field. That's where you're going to be uploading a letter of explanation and any supplemental information or documents that you need to attach there.
Yeah, and Alicia, I'll use this opportunity to direct MX to a very old video. Let me see. It's like 5 years ago. Mark looked completely different at that time.
Mark Holthe here. Can
So
you
Mark
answer them?
guides you through all of those statutory questions and how you should answer each one of them. So you will see that some questions take like 4 lines. And so you need to read through the question very carefully, because sometimes you see it talks about Canada, yada, yada, yada for 3 lines, and then, or any other country at the very end. And so there are 2 questions that if you answer yes to one question, then obviously you would need to answer yes to another question, like have you been refused entry? And then you would just need to use the same explanation or different explanation depending on your situation. So check this out. Just search for how to answer statutory questions in your EAPR, and it should take you to this video on our YouTube channel. All right, let's go back and we'll answer one more question and then we'll slowly start to wrap up. And we'll also introduce you to some other things that we are planning. I'll get to that just in a minute after we answer the question from Clement. So his wife is on a religious worker LMIA-based work permit for the past 1 year in Ontario, and can she enroll in Express Entry or apply for permanent residence? The short answer or long answer?
Clement, this is a really tough question because there were exceptions, so some religious workers under 205, Section 205 of the Immigration Refugee Protection Regulations don't need a work permit at all, and some of them do. And so it's good that she had an LMIA-based work permit. It's a different category of work. You might be okay to have your wife applying as long as she meets all the other minimum eligibility criteria, but it's also going to depend on whether she can prove that she had 1 year of Canadian work experience, if you're looking at CEC, on that LMIA-based work permit in the past, or if that's a new thing. Maybe she can qualify for federal skilled worker because she has work experience outside Canada that was paid work within the same NOC. But religious workers it's a little bit trickier. And some of the provinces won't allow people to apply for a PNP on a religious worker type of work permit. So that was one thing that Alberta was changing their policy on. So there are some provinces that do and some provinces that don't. So this one's a tricky question.
Yeah. And as we promised, we're gonna wrap up. But before we do this, I wanted to share the screen and just once again remind everyone that December 18th to 21st is when we're going to have the new masterclass for Express Entry. It comes at a price just a little over the price of the consult, so $347 US. And then when you subscribe to the course, you get access to 642 minutes of video instructions, and they're really detailed instructions. So by the time you watch the course, you finish the course, you will know everything you need to know about Express Entry. And if there are some uncertain moments or you want to double check or clarify something, you don't need to book a consult. You just need to join Mark for one of those 4 masterclass sessions, hour-long videos. And if your question is not super specific, that requires a little more information from you, you should be able to clarify something from Mark during the masterclass. Those masterclass sessions come as a supplement to the video materials. So again, December 18th to 21st, you still have some time to enroll. And then the next thing is for those people who want to come to Canada, who don't have any connections to Canada, but those who know French, at least on some basic level, this is the video that we have scheduled for tomorrow. For tomorrow, in 21 hours from now, we'll have the video with Jean. Jean is a French language tutor who explains how to succeed in TEF. So this is not for those people who don't know anything about French. It's mostly for people who have some proficiency in French and want to improve their score so that they can get those valuable extra points and qualify for the French-speaking category draws. So absolutely check it out. If you're thinking about studying French, then it might be of interest to you as well, so that you get invested into this topic a little more before you even start studying French. So absolutely spend your time, and when you get to our YouTube channel, just make sure that you hit the subscribe all bell icon, and then you will get a notification when this video goes live. So that's it. Just 2 announcements that I wanted to share before we wrap up. Alicia, any other final comments?
I just wanted to say thanks so much, Igor, because, Igor's our articling student right now, but it's been a long journey for Igor. And Igor has so much institutional knowledge about Holthe Immigration Law. He's literally been here from the beginning, and he's been, he's trained as a lawyer, but he's an absolute wonder with helping create these courses, helping put out these podcasts, helping do thumbnails, helping do all the background IT work as well. So, for Igor to just sit here and pull up this video from 5 years ago, because he knows what Mark was doing 5 years ago and he was helping produce those videos. So hats off to you, Igor. Thanks so
Thank
much
you.
for pulling up relevant information from the past as well.
Thank you. Yeah, and I wish everyone luck, and I really hope that there will be a draw, because if there's no draw in November, that's gonna be a big news. Like 1 month without any single draw. That reminds me of COVID times. But
I know,
we'll
I know.
not focus on the negative. We'll focus
No,
on
and
the positive.
we'll focus on the positive. We'll hope that there's going to be draws. We hope that they've figured out their situation. I didn't see anybody chime in about whether they got the extra 60 days. It seemed to be happening for other people. So, that does worry me a little bit. Like if they did the October 26th draw and then they gave people an extra 60 days, I'm hoping that there will be another draw before 120 days go by. So we shall see. Keep studying French if you can. Try to get those CRS points, and for sure tune in to that TEF podcast video tomorrow that will be aired, and Mark is going to be doing that. And a lot of people are really interested in French, and that's what Canada is trying to promote right now. And so if you are learning French and you've got decent levels of French, then continue on.
Yeah. All right. So goodbye, everyone. We'll see you. Are we doing the live Q&A tomorrow, Alicia?
No, we've moved to only Wednesdays, so
Okay.
we'll
Okay.
see you next Wednesday.
Next Wednesday. Yeah. Okay. Take care, everyone. Bye.